Good afternoon to all participants in the online public hearing organized by the Independent Evaluation Commission for assessing the integrity of candidates for the position of member in the self-administration bodies of judges and prosecutors pursuant to Law Number 26/2022. I hereby declare this session open. This hearing involves the resumed evaluation of Mr. Alexei Paniș, candidate for the Superior Council of Magistracy and judge at the Chișinău Court, Rîșcani Office. I would like to welcome you, Mr. Paniș. We are here to conduct an online public hearing in the context of the resumed evaluation process aimed at assessing candidates for the position of the Superior Council of Magistracy. The Commission is acting in accordance with Law Number 26/2022 and its rules of procedure. On the screen in front of you, you have the four members of the Commission today: Nadezhda Rîșcani, Tatiana Raducanu, Nona Tsetsoria, and myself, Herman van Hebel, the chair of the Commission. I was informed earlier that Victoria Hanley will not be able to participate in the hearing today. The Commission is assisted by members of the Secretariat, and the online public hearing can also be followed by representatives of the media and the public. During the hearing, interpretation between Romanian and English will be provided. To allow for accurate interpretation, I would kindly ask you to speak clearly and slowly. Furthermore, the proceedings are being recorded and the public parts will be available online, generally within 24 hours after the hearing, via the website of the Commission, www.vetting.md. I will start with a brief overview of the procedural background of this resumed evaluation. On 24 January 2023, the Commission issued a decision in relation to your integrity evaluation for the position of member in the Superior Council of Magistracy. In its decision, the Commission decided that it had serious doubts about your compliance with the criterion of financial and/or ethical integrity in relation to three issues. One, the source of funds for a 300,000 lei loan and money used from your father's salary card. Two, the sale of a Kia Sorento car and cash investment in the house located in Chișinău municipality. And three, public statements by you as candidate on 19 January 2022. On 13 February 2023, you appealed this decision to the Supreme Court of Justice. And on 1 August 2023, the Supreme Court of Justice annulled the Commission's decision and ordered a re-evaluation. On 9 September 2023, the Commission started the resumed evaluation, and on 25 March 2024, pursuant to Article 19, Paragraph 1c of its Rules of Procedure, the Commission sent you a statement of facts and serious doubts. On 1 April 2024, you responded in writing to the statement of facts and serious doubts, and you informed the Commission that you wish to participate in a public hearing. During this hearing, the Commission will take into account your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details relating to, for example, ID numbers, bank account numbers, addresses of real estate, and the like. For the protection of your own privacy, we ask you to do the same. The present hearing takes place at your request. The hearing will be focused on the statement of facts and serious doubts that the Commission has sent to you and your written response to the statements of facts. I will briefly explain the procedure for today's hearing. For each issue included in the statement of facts and serious doubts, you will be given, if you so wish, a maximum of 15 minutes to briefly provide additional explanations to complement your written response to the statement of facts and serious doubts that you submitted to the Commission. One or more members of the Commission may have questions for you about the explanations you have provided, both in writing and during the hearing. I urge you to be concise in your explanations and answers. I also urge you to answer all questions truthfully and completely. Your explanations are important to the Commission, in verifying your financial and ethical integrity. I myself will start with leading the discussion with you on the statement of facts and serious doubts in relation to the first issue that I mentioned, the source of funds for a 300,000 lei loan and the use of money from your father's salary card. Mr. Paniș, you would like to say something?
Da, dacă îmi permiteți două aspecte.
Yes, if I may, two clarification aspects regarding the regime devaluation. What happened to the, or what happens with the member that is absent today? Will she take part in making the decision, or will the decision be made only by the members that attend the hearing today?
That is a legitimate question, and the answer to that is that the decision will be taken by the 4 members that you see this afternoon. As I mentioned, Mrs. Hanley is not able to participate, and she will not take part in the decision-making on your case. Is that okay? Shall we proceed with the first issue?
Am o întrebare referitor.
I have a question, a clarification question about the possibility to continue the hearing, and I will explain why. In line with the provisions of Law 26, the Commission is following the Constitution and its own regulation that was approved, Rules of Procedure. Article 2, Paragraph 2 of the Rules of Procedure of the Commission says that the Commission shall follow the Constitution and the approved regulation. Like own regulation approved by the Commission states clearly that the working language of the Commission is English, which means all correspondence between Secretariat and Commission members is in English. That is mentioned explicitly in Article 4, Paragraph 1 of the Rules of Procedure. Paragraph 4 of the same article states that the Secretariat shall translate every document at the request of a member. In other words, not all materials are translated, only in a selective way when members ask for them to be translated into English. That's what follows from the provisions that I read now. During the initial evaluation, it was found that there was a lack of translated materials about me. That was also found by the Supreme Court of Justice. So there are documents missing that, well, documents translated into English that are missing. That was found by the court. The Commission includes 3 foreign citizens. That's good on one hand because they are not members of the Legal Resource Center. They do not know Romanian. So initially, during the initial evaluation, I was refused to be given the materials. It was said that the Commission denied the existence of materials, and then in the court hearing, the attorney of the Commission lied to the court and said that there were no additional materials because ultimately, during the resumed evaluation, I was provided with 6 binders, 3,478 pages in Romanian. My question is, have all these materials been translated into English? And do the members today have all these materials translated to English in front of them? This is my question. I want to know if the Commission is ready, is prepared for this hearing, or the Commission just has in front of it a report by someone from the Secretariat. Again, I'm speaking about 3,400 pages. Do you have them in English?
All right. Thank you very much for your question. And the answer to that is very straightforward. You rightfully referred to the Rules of Procedure, Article 4, that deals with languages. And in accordance with that provision, the Secretariat, if I just quote paragraph 4 of Article 4, and it says that the Secretariat shall ensure that all communication with the candidate is translated into English. Upon the request of a member, the Secretariat shall ensure the translation into English in writing or orally of any materials received by the Commission. That's exactly the working methods that we have applied, and wherever any of the members of the Commission who are not able to read the Romanian language did feel a need to have access to materials in writing or orally to understand the full case, then we were able to ask the Secretariat, and the Secretariat has been able to provide us with that. That has been the standard practice, and we are confident that all 4 members that you see in front of you are able to fully understand the process and all the issues involved in the case. I hope that answers your question. Are we able to proceed now with the first issue, Mr. Paniș? If so, then I would like to read out.
Did I understand correctly that these materials were not translated, but selectively some translations out of these 7 binders, 3,470 pages, only some of them were translated and provided to you? Is that finding correct?
As I mentioned, Article 4, Paragraph 4 reads that the Secretariat shall ensure that all communication with the candidate is translated into English. Upon the request of a member, the Secretariat shall ensure that the translation into English in writing or orally, I would like to emphasize that, of any materials received by the Commission. That has happened, and I can reconfirm again that the Commission is fully appraised of all relevant materials for the hearing this afternoon and for the resumed evaluation of your case. So I think with that, I did answer your question. Shall we then proceed with issue number 1? The issue number 1.
Cred că da, mulțumesc pentru răspuns. Dumneavoastră ați confirmat
I think so. Yes, thank you for your answer. You confirmed that these materials were selectively translated by the Secretariat. I highlight that during the question rounds in the initial, I found incorrect translation of materials that were provided to the Commission members by the Secretariat. So I don't count on the good faith of the Secretariat now. The case of Iulian Muntean showed us that we cannot trust this Secretariat. Yes, we can move to the statement.
Mr. Paniș, this case has nothing to do with the any other cases. Your qualifications as to whether or not there is trust in the Secretariat, I leave it entirely to your assessment. That is not the assessment that the 4 members that you see in front of you have. We have the full trust that the Secretariat did exactly what we asked them to do, and which is in conformity with law number 26 and with our rules of procedure. And I don't think I have to repeat the language that I already read out to you twice before. So let's get started with the first issue for this afternoon. As I mentioned, that is the source of funds for a loan that you took from your father of 300,000 lei and the use of money from your father's salary card. In relation to this issue, the Commission, in a statement of facts that was sent to you on 25th March 2025, formulated the following serious doubt, and I just quote: "The Commission has serious doubts about the financial and ethical integrity of the candidate in relation to his receipt and use of a loan of 300,000 lei and use of a salary card for an amount of 58,927 lei from the candidate's father, while the candidate was aware that his father was the subject of 3 verification procedures by NIA relating to the candidate's father's position as president of Flores district, while at the same time being engaged in and receiving a considerable income from private economic activities in violation of the legal regime of incompatibilities and related issues of legality of funds acquired over the years 2012 to 2020. In relation to these doubts, the Commission has a number of questions to you. My first question to you is, can you confirm that your father was the president of Flores district from 28 March 2012 until 1 December? No, wait a minute. We first have to give you the opportunity to make your statement for about 50 minutes. I overlooked that. I do correct myself now. So I'm sorry for that. So I give you the opportunity now, Mr. Paniș, to present the case in relation to this issue for 50 minutes. And then, of course, I will repeat the question and other questions that we have for you. I apologize for this oversight. Mr. Paniș, please go ahead.
Deci, până ca să explic situația dată.
Before
Ajutați-mă să
explaining
înțeleg
this
care
situation,
sunt
help me
dubiile comisiei.
understand what
Pentru că
are
eu
the
am citit din
Commission's doubts,
notificarea care
because
prezentat-o
I
și care
read
ați dat
the
citire acum.
statement that
Se
you
spune,
submitted to me and
Comisia
that
are
you
dubii
read out. It
serioase
says
cu
that
privire
the
la
Commission has
integritatea
serious
financiară
doubts
și
about
etică a
the
candidatului
financial
în
ethical
privința primirii
integrity
și
of the
utilizării de
candidate
către
regarding the
candidat a unui împrumut
receipt
de
and
300.000
use
de
by the
lei.
candidate of a loan of
Am în față
300,000
legea
lei. I
26
have
și care ne
Law
spune
26 in
clar
front
la
of me, which
articolul
says
8
clearly in
alineatul
Article
4
8, Paragraph 4,
cum se stabilește corespunderea cu stării de
how
integritate financiară. Și
compliance with
anume,
the financial
el vizează
criteria is
dacă averea
established.
candidatului
Namely,
a fost declarată în modul
it's
stabilit de legislație
if
și dacă
the
comisia
assets
constată
of the
că averea
candidate were
dobândit de
declared
candidat
as
în ultimii
provided by the
15
law,
ani
and if the
corespunde
Commission
venitului
finds
oficial.
that
Deci
the
ajutați-mă
assets
să
of
vă
the
dau
candidate
răspunsul
acquired in
corect.
the last
Care sunt
15
dubiile la
years
capitolul
were
dat? Că nu
according to the
corespunde
official info.
averea
So what are the doubts?
sau că nu a
Is
fost
that my
declarată în
assets
modul
don't
stabilit de
comply
lege.
or it wasn't declared
Puteți să-mi explicați? Pentru că eu
as
am
provided
explicat
by
asta
the
la
law?
evaluarea
Could you
inițială,
please
dar
explain that to me?
comisia nu a
Because I
ținut cont.
explained this during the
Deci, care
initial
sunt
evaluation,
totuși
but the
dubiile la
Commission did
primul
not take that
subiect și
into
eu să
account. So
răspund
what are
concret
the
la dubiile
doubts about the
comisiei
first
și le
issue? And I
elucidez
will
prin prisma
answer.
legii.
I will clarify specifically the doubts of the Commission according to the law.
The doubts are not only laid down in the serious doubts as I just read out, but of course also in the remaining part of the statement of facts. So we have provided you a detailed overview of all the facts that we have collected during the initial evaluation, also during the resumed evaluation. We had some written question and answer sessions with you, and of course we have sent you the statement of facts and you have been given the opportunity to respond to them. That is the complexity and the totality of all these facts, and all arguments and issues are on the table for our resumed evaluation this afternoon. I don't think I have to highlight any of those. It is the totality of all those facts laid down in the statement of facts that has culminated in this serious doubt formulation that I just read out. And it's in relation to that serious doubt as I formulated it, and all other facts that we seek your feedback on at this very moment. So again, please go ahead, Mr. Paniș, and present to the Commission anything that you would like to present in relation to the totality of these facts. Please go ahead.
Exact asta a constatat și Curtea Supremă de Justiție.
That's exactly what the Supreme Court found, the impossibility of the Commission to qualify the held facts in terms of Law 26. The Commission just described circumstances that it did not accept and could not describe why the candidate does not meet the financial integrity criterion. The law states clearly in Article 8, 4 letters A and B, and today it's confirmed to us more that the Commission cannot qualify correctly these circumstances, and I will explain repeatedly the circumstances described in the notification. I'd like to explain that both in the initial evaluation and during my appeal against the Commission's decision, it was found certainly that my father had enough financial resources obtained legally to give me that loan. In the conclusion of the court, it was mentioned expressly that the Commission did not have a serious and logical reasoning that would explain how my action of getting a loan from my father could lead to non-compliance with the financial integrity criterion. This amount was taken as a loan. If the Commission looks carefully into the declaration of assets and personal interests filed by me, in the period when I took a loan from my father, I contracted a loan from a commercial bank from Moldova. That bank was and is still investigated in a criminal case related to the bank fraud. The actions of that bank, not the actions, sorry, the goods, the assets of that bank are under seizure in an amount of around 2 billion lei. There are accusations about participation in the bank fraud, accusations about money laundering for the interest of an organized crime group. Following the logic of the Commission from this statement means that me contracting a loan from that bank is also leading to me failing the evaluation. Moreover, many judges have salary cards with that bank. Is that also a violation? In the light of the provisions of the commissions that they were not able to identify. I explained that and I reiterate that the only act that is valid, that is enforceable, issued by the National Integrity Authority is the report on verification of declarations that confirms that in the year when the loan was taken, the legal income of my parents was over 1,300,000 lei, and they had the possibility to loan me 300,000. And again, that was a loan. I highlight that. The Commission analyzed all materials submitted by the National Integrity Authority, except the decision of the Court of Appeal of Chișinău, which partially accepted the appeal and annulled an act. And I will read the decision just a second. That's a decision of Chișinău Court of Appeal that annulled report number 3-13 of 10th of April, and it's stable that this is about the incompatibility. In this specific case, no damage was caused to the public authority. My father did not got any benefits from that activity, and I would like to pay attention to this incompatibility aspect, saying that the chairperson of the pre-vetting commission, according to the press release on the Facebook page of the Pre-Vetting Commission, admitted that he was the chairman of the commission at the same time a judge in a court of appeal in Den Bosch. For that activity, he was paid. And this incompatibility did not prevent the chairperson to have the same reputation above reproach that each member of a commission should have, and he is part of today's hearing, as opposite to my father. So my father was not paid for that activity, and the commission is misled by the secretariat, because as you mentioned in the income, he had income from economic activities false, and no document issued by NIA, it was stated or found that in that activity my father was paid by the company he was leading. I'd like to draw attention. What's the practice of the National Integrity Authority in similar cases, but about other people, probably of another category? Namely, on 10th of December, NIA issued document 337-8 about Lilian Karp, a member of a parliament from the governing party and chairperson of the National Security Commission. Here, NIA found that even though he was simultaneously an MP and chairperson of a legal entity, he did not violate the regime of incompatibilities because he was not paid for being the chairperson of a president of the legal person. That is a similar case, and that is the practice of NIA in all similar cases, if you look into their portal. When it comes to the report on the allegedly illegal income, I mentioned, and I'm sorry that at the previous hearing the Commission did not take into account the arguments I provided and did not include them in the decision. I explained the way how that document was issued. That document is not enforced, and the conclusions of the integrity inspector deny the insinuation of the Pre-Vetting Commission, because the document issued by the integrity inspector confirmed that the income was higher than expenses. I described it in details, but the Commission did not want to accept my explanations. I will insist for these explanations to be included in the decision. Moreover, when it comes to non-compliance with provisions on declaration of assets and personal interests, another member of the Commission, Ms. Raducanu, document of 17th of July by the National Integrity Authority, the inspector found that there were assets that were not declared in the declaration, but the inspector accepted the explanation that it was not done deliberately.
You have no further comments in relation to this issue, Mr. Paniș?
Deci eu le-am expus detaliat în răspunsul la notificare.
I provided them thoroughly in my answer to the statement, and I hope that the Secretariat translated it to the Commission members.
Okay, then let's proceed with the questions and that the first of which I already started reading out to you, but I will repeat it now again. So the first question that we have for you is, can you confirm that your father was the president of Flores District from 28 March 2012 until the 1st of December 2023?
Dar asta am confirmat și la evaluarea
Yes, I confirmed that during the initial evaluation as well. I don't see the reason for repeating it. I mean, if you have any new question, let's go to them. But otherwise, I hold my explanations from the initial evaluation, both the written answers and what I said by email and the statements that I made before the Commission. So we're repeating, and I said that because I said the same thing in the initial evaluation. If you have other questions, additional, let's move straight to them.
We do. My second question is, can you confirm that from 20 April 1999 until 9 April 2019, your father held the position of manager of the company that we now call P Limited Company? Can you confirm that your father established another company with the abbreviation of EG on 10 September 2012, so that is after he became president of Flores District, and that he held the position of manager in this company from 18 March 2019 until 27 May 2020?
Nu am extrasul din registrul persoanelor
I
juridice.
don't have abstracts from the register of legal entities, but probably that's true.
Okay. My next question is, can you confirm that according to Moldovan law, a public position such as that of president of Flores District is incompatible with holding official positions in private companies? And can you also confirm that a violation of this incompatibility rule amounts to a criminal offense?
Este un absurd să considerăm că este o
That's
infracțiune
absurd to call it a criminal offense, to call the violation of incompatibility is a criminal offense. And this is proving that the Secretariat misled you again. This is not true.
Okay. The next question to you is, in response to the statement of facts, you state that your father is not a lawyer. Does that have any impact on the applicable rules relating to incompatibilities?
Cu siguranță că da, trebuie studiați
Yes,
practica
of course,
NIU-ului.
you
În
need
privința
to
doamnei
study the
Rîșcani,
practice
inspectorul a
of
considerat
NIA.
că nu
With
este
respect
încălcare
to
doar de
Madam
motiv că nu a
Raducanu,
făcut-o
the
intenționat.
inspector found no
Deci
violation
fiecare
because she did not do
circumstanță
that
trebuie
deliberately, which
analizată.
means every circumstance has to be
Multi-aspectual și complex,
analyzed
caz în
from
caz în parte.
in a
Deci, cu
multi-aspectual
siguranță că da.
way. Each individual case has. So yes,
Și anume actul respectiv confirmă asta, că
certainly. And this
inspectorul a
document
analizat.
proves that
Este
the
încălcare
inspector
dată,
analyzed
a
was
fost
there
avut loc faptul
violation
dat sau nu,
or not, or did
intenționat,
that
neintenționat.
take place
Ea
or not,
contează.
deliberately or not. All of that matters.
Okay. My next question is the following. Can you confirm that the income of your father as president of the Flores Council over the period 2012 to 2021 amounted to about 1.1 million lei? So that is on the average less than 100,000 lei per year.
Eu nu pot să confirm
I cannot
aceste date.
confirm
Ele se reflectă
these
din
data.
declarațiile de avere și
They
interese
are
personale.
reflected
Exact în
in the
maniera în care
declaration
sunt
of
indicate acolo,
assets
ele
and
asta
personal
trebuie să
interest.
corespundă, dar nu am un
So
grafic al
they
acestor
are
plăți și
exactly
nu
what
le cunosc
is
exact
mentioned in
și
the
care. Dacă este
declarations.
indicat
I
în
don't know them
declarația de
by
avere și
heart.
interese
If
personale, asta
that is
este.
what's
Mai mult,
mentioned in
aplicația
the
trebuie să
declaration of
rezultă și
assets
din
and
actele de
personal interest,
consultare a
that's it. This also should be resulting from the reports of NIA.
Okay. My next question is then, can you confirm that your father purchased a total of 547 plots of agricultural land at a total value of 2.8 million lei since he became president of Flores District?
Asta se referă cumva la suma împrumutului
Is that somehow related to the amount of the loan? Because during resumed evaluation, we're supposed to discuss aspects related to the decision of the Court of Justice. So is this related to the amount of loan? Is this question related to the amount of the loan? Because the first issue in the note in the statement is that is about the loan and about the use of the bank card. So the purchase of land plots. I don't understand how is that connected to this. Could you please explain that to me and then we can continue?
Of course, I can explain, but I think in the end, we will, of course, explain the totality of all facts in our final resumed evaluation decision. What we try to do here, as you can imagine from our questions, is that we try to establish a complete financial picture of your income, the income of your father while he was president of Flores District, and any other income that he may have had, and any other expenses. It is that total picture, of course, that we try to establish and that we seek your
Exact asta se reflectă în actul de constatare.
That's exactly what's in the statement of finding. We need to look into that statement of the inspector, and then we can look at the income separately and at the expenses separately. In addition to that, in the answers to that statement of facts, I answered to how this procedure has happened regarding this verification of the assets of personal interest and the materials that were presented by the Commission that were received from NIA that confirms that the State Tax Service was not requested to identify, to provide a list to identify all of the income, and that's why I explained in my answers to that statement of facts.
Okay, thank you. My next question is then, can you confirm that your father leased many agricultural plots of land to company in which he owns shares himself?
De către cine au fost date?
Leased by, you mean who? You mean my father leased those land plots to the company in which he had shares? Or could you please reiterate the question? Who was leasing them?
The question is whether your father, as a private person, leased agricultural plots of land to companies, and in which he himself had shares in those companies. That is my question.
I am not aware of the companies who he leased the lands to, but that is certainly not an incompatibility with his position, and there's no issue in this regard.
Okay. My next question then is, in your response to the statement of facts, you emphasize the fact that during the period your father was president of Flores District, he did not receive a salary from the companies for which he was at the same time registered as administrator and or director. Can you explain what legal difference that makes from the perspective of the applicable rules of incompatibility?
Well, as I explained, in that period of time, he was exclusively being provided dividends on the basis of the law on limited liability companies, and that is not a violation. Those actions do not amount to a violation because the law is clear, saying that there is a situation of incompatibility if the person is rewarded, is paid on the basis of that activity. So obtaining dividends from his company is not a violation, and that cannot entail any violation whatsoever, and that is very simple. That's what we can see even out of the law on declaring assets and personal interests too.
So you're basically saying that receiving dividend is not a reward in the sense of the law that you just referred to?
It is not a violation in the meaning of the law, and it's not myself saying that, but that's what the law says, that's what NIA inspectors say, that's what the practice of the NIA says, and that's what the judicial practice says, and that's what the current situation says.
Okay. My next question then is the following. Can you confirm that your father received dividends in the total amount of over 2.8 million lei in the period 2015 to 2018 from the company P, over the operational years of 2002 to 2007. And can you then, sorry, go ahead, yeah.
I don't know for certain what exactly the amounts were. They were put down in the documentation that was provided, that is in the case file.
Okay. And then
but you could check the declarations of MPs, of members of the SCM, of the SCP. If you look at those declarations, you will see that a lot of people get dividends from the companies that they own or where they have shares, including people who have already gone through this exercise. It's not a violation. It's only there's a difference between remuneration by means of a salary that is paid for one's work in a particular company or dividends. So these are different.
Okay. As a follow-up question here as well is, can you explain why in 2015 your father was given a dividend of just over 1 million lei over the years 2002 to 2007, and in the subsequent years 2016, 2017, and 2018 again was provided dividend over those years 2005, 2006, and 2007?
I can't explain how the associates decided to distribute the dividends. That is the decision of the associates. They can agree on, let's distribute something this year, next year, another year, or not distribute the dividends, but rather invest them in the business of the company. So I don't know what they thought and how they decided, the associates of the company, to distribute the dividends. It's their right to make a decision that regard, and they used it. They don't have any obligations except for those that they were supposed to, and they made their decision on how to best divide and distribute the dividends.
Okay. And can you then explain why these dividends were paid to your father more than 12 years later than the operational years of the company itself?
I don't see any reason for this to be regarded as a violation. It could have happened 10, 20, 30 years later. I would like to reiterate that I am not aware of the exact reasons why they decided to do it like this. Maybe they decided to make some investments in the company initially, and then I don't see what the issues is and how these are connected. The company, the associates make the decision, and this company has nothing to do with the authorities of the state. That is a company where the associates decide, they can decide on when to withdraw the dividends, nobody else. It's only the associates of the company. That's why they decided. That's their decision, and there's no violation whatsoever in this regard. I am not knowledgeable about the reasons. I don't know what the reasons were and what the logic behind those actions was. The dividends were paid out, and those are legal funds.
Okay. And is such a practice of paying dividends more than 12 years later after the operational years, is that a practice that is allowed under Moldovan law as far as you are aware?
I don't know, but I don't see what the problem would be. And in this situation, then, how is that connected to my evaluation? The company has never been penalized for those actions. There's been no issue raised with paying dividends more than 12 years later. What if the dividends were paid 7 or 3 years later? Would that have been an issue? I think we should look into the law. I did not look into the details of the law regarding dividends in situations like this, but I don't see currently an issue.
Okay. And so you did, a couple of years later, you did take a loan of your father, whereas you're not entirely sure whether the paying of dividends under Moldovan law in the way it was done by your father's company was entirely correct under Moldovan law.
Well, if you mean my participation in the meeting of the associates in voting, I have no idea about that. All I know is that my father had enough funds to give me that loan, given that he was engaged in legal activity. That was legal. When the dividends were when the decision was made to distribute the dividends, I did not participate in that meeting, and I have nothing to do with the payment of dividends. However, what is essential to underscore is that the document of the NIA is the only one that is enforced. There is the report on the verification of the declaration. And in this case, the National Integrity Authority confirmed that the income in that period of time was legal, that the income obtained in the period in which the loan was provided to me was legal.
My next question is the following. As you confirmed during the initial evaluation hearing, you were aware of the fact that NIA initiated a verification of your father's assets and personal interest on 7th July 2020. Still, after you became aware of this fact, you took a loan from your father of 300,000 lei and used his salary card for nearly 60,000 lei. My question is, don't you think that as a judge, you have the obligation to ensure that source of funds used by you are of an undisputed nature? And do you, in that respect, consider it ethical to make use of funds of which you are not aware they are of an undisputed nature?
What the evaluation commission overlooked is the fact that the period of verification was the one that was before that period in which I was given a loan. So that's verification. Now, setting aside the violations and carrying out at all, I've described them in detail in my response to the notification, to the statement of facts, and I hope this will be, my answers will be there in the evaluation decision. That period of time was actually one that was preceding, before the one in which I was given the loan. In that period of time, the National Integrity Authority established, so the National Integrity Authority, I underscore, established that there was income more than 1 million lei from legal sources, and therefore then a loan was taken. If we follow that logic, we need to remember that all the loans provided by banks, by a bank in a criminal case around the banking fraud, there was money laundering for the interest of an organized group crime. So they were in the same or a similar situation. This is absurd. These are different periods of time. There is documentation that shows where the money came from, and that was a loan. As regards the salary card, as I explained at the initial stage and in the hearing of the initial evaluation at the Supreme Court of Justice, that card was a card for the salary. The salary was coming from the state budget. That's the money that was going to the card, and that was the salary for my father's work. And it has nothing to do, and the commission is being misled. I underscored in my response. It says that my father had income from economic for entrepreneurial activity, but he didn't have that sort of an income. All he had was dividends. And then another false information is that the NIA requested for the assets to be seized. Well, actually, there's all the materials of the NIA, and if you look at that, you will not be able to draw these conclusions. So that's why it's important, because all about 4,000 pages need to be translated, because I don't trust the secretariat that is supporting you. In the regulation, the Commission says clearly there's a difference between the English version and the Romanian version, that the English version will prevail. But in this particular case, well, the regulation is 4 pages. I have 3,400 pages, and I don't know whether that was even, those pages were even translated into English at all, and how many of them were. So all the answers that were annexed, all my answers to the notification, I hope they were all translated and made available to the Commission.
Okay. My next question is then the following. If your father would have fully respected the rules of incompatibility since he became president of Flores District on 28 March 2012, would your father then have been able to provide you with that loan of 300,000 and would have given you the opportunity of using the salary card for nearly 60,000 lei?
Well, I answered that when I've answered the previous question. First of all, there is no document establishing there's been an incompatibility. Next, he was remunerated from the state budget and from the company. He only received dividends. I reiterated, please do look into the declarations of SCM, SCP members of other officials, and you will see that this is something common that is often come across, and it's not a violation to receive dividends from a company where you are an associate or where you have shares. It was obvious. There was no issue for me to get that loan. If he observed, you said, well, who established that he didn't observe it, or if he was in violation with anything? Because those documents that claim that are not enforced, they are not valid. The fact that currently the chair of the commission has an irreproachable situation, given the claims of incompatibility, there should be the same treatment applied. There is no act of the national authorities in force such as to produce legal effects, so we cannot raise any claims of incompatibility or claim that there's been one. The only document that is in force is the one that confirms the source of the income greater than 1.3 million lei in the period in which the loan was granted.
Okay. My last question in relation to this issue then is the following. Do you have anything else to add or clarify in relation to this question that we just discussed with you?
I believe I described certain aspects regarding and around all these processes, and I think I don't have to make this public right here, but I would like to kindly ask the members of the Commission to pay attention to the judicial practice and to pay attention to how the same panel of judges issues a particular solution regarding Paniș Stefan and a different solution regarding the person that I will not say the name of, but it's the same panel of judges. 3 or 4 months apart, that same panel applies the law in the way that I described to you and in my previous answer. So it'll not be fair and right to say the names of my colleagues out loud, but I've already explained. I would like to kindly ask the members of the Commission to pay attention and to look at or to look this up on the website of the National Integrity Authority. There's a documentation, there's the official decision from the decision regarding incompatibilities. I would say the position is very clear. Remuneration is an indication to confirm whether or not there's that incompatibility, and that started from the cases that I've already referred to earlier. And this is why I would like to kindly ask that my answers be translated in the exact way in which they were submitted. There is nothing else I could ask for or add regarding this issue.
Okay, thank you very much, Mr. Paniș. I would like now to pass on to my colleague in the Commission, Tatiana Raducanu, to continue with the second issue that we have for discussion with you. Thank you so much.
Thank you. Bună ziua, domnul Paniș.
Greetings, Mr. Paniș.
Bună ziua, domnul Paniș. Cu referire la problema 2.
Regarding the second issue, the Commission has serious doubts as to your financial and ethical integrity as regards the accuracy of your declarations and statements in relation to the sale in 2017 of a Kia Sorento car and the sale of a Hyundai Tucson car in 2020 and the purchase in 2021 and the sale in 2022 of a Yamaha Virago motorcycle. And regarding expenses of 300,000 lei for the demolition of a house and for initiating the construction of a new house in the first 3 months of the year 2019. With regards to these, you can take the floor for 15 minutes to address them. As regards the sale of the vehicles, I would like to reiterate that it is not clear how the Commission established that the financial integrity criterion was not met. I've explained whether there was the decision of the Supreme Court of Justice that established that the conclusions were not well founded as regards the serious doubts. So I requested during the initial evaluation and in the resumed evaluation, I requested for the prices of the vehicles to be compared, of those particular vehicles that you named, and I asked that they be compared to the prices of similar cars on the market. I don't understand why the Commission is not giving me equal treatment and is discriminating against me compared to other cases. So there is a market value of these cars, and that is obviously to be looked at to make sure that the candidate reported fairly. So essentially, the Commission turns out that it has some doubts as to whether the real actual prices of the transactions were declared. For every time that I sold a vehicle, I indicated the real price in the declaration of assets and personal interest, the real price that was also the market value. I have thoroughly analyzed all of the decisions of the Evaluation Commission, and I've also produced examples where the Commission has had a completely different treatment to all the candidates. All the doubts can be cast away if you simply go to the specialized websites where you can check if the price that I declared matches the market values. But that seems not to be desired in my case, because that would be the right thing to do. I've always indicated the real price, and every time it is the price that matches the market value. For instance, in decision number 26 of 13 March, the Commission has analyzed details about an exchange transaction whereby the candidate obtained a car for 9,000 euros, by 9,000 euros more compared to the price of the car he was offering for exchange. In the case, the Commission looked at the prices that can be found on specializing websites, and in the hearing regarding my appeal, the lawyer of the Commission agreed that that verification was done because there were some doubts as to the real price. In decision number 4, there was the 9th of December, the Commission justified its doubts about the real price for a car because when it looked up prices for similar cars, and it looked to 3 websites that it referred to, it did that ex officio. But in this case, the candidate declared a price, the Commission questioned it, it looked it up on the websites, and the Commission did not only do that, but it looked also at the situation of similar cars by model, by year, and it managed to argue that the prices declared by the candidate did not match the market values. And that is totally different from my case, because to this day, the Commission is refusing to look at what the market values are. Another decision is one where the Commission accepts that a car was imported for 50,000 euros and that the candidate allegedly paid import taxes of 98,000 lei. And when the car entered in the country, it seems that the price declared of the car was 200,000 euros. That is a few times more than what the candidate declared. And the Commission accepted what the candidate said because the car was not in a good condition. But it only turns out that it still required only 1,000 euros to repair that car that was not in a good condition. So that raises some questions. Next, decision number 41, the Commission accepted that some cars were bought for very small prices, like 2,000 lei, that is 100 euros, and without having looked up what the market value was for cars of that model. But actually, just a tire costs 900 lei. for cars like that, that is particular, like 18% of the 5,000 price for the car, so to speak. So the point I'm trying to make is that in other cases, the Commission has accepted some very small prices. And then decision number 40, the decision regarding Madame Varlan, by the way, the Commission established that in 2018, the candidate became the owner of a Toyota Aygo car, the one that she's purchased for 60,000 lei. In the sale and purchase agreement, it was, the amount region was 8,000. So all that the Commission upheld is that it was not ethical to include in the contract something that is not realistic, but that is not a violation to amount to violation of the ethical integrity criteria. And decision 42 of the 12th of June 2023, the Commission established that the candidate entered into a transaction to buy an asset for a contractual value of 13,000 euros, but actual price was 31,000 euros. And the only finding of the Commission is that it was not ethical for the candidate not to include the actual price of the transaction. The difference between the actual and contractual price was 20,000 euros, and no doubts were raised with regards to that candidate. Decision number 3 of the 26th of October, the candidate sold real estate for 6,000 euros, but for that transaction, they actually received 205,000 lei. And what the Commission upheld is that the candidate kept the amount of 123,000 lei, actually, sorry, and that the difference was given back to the seller because they've accepted an amount that was bigger than the actual one because the buyer needed a loan. So the Commission upheld that the bank financed a bigger loan for the buyer, and the candidate did not have any desire to hide away the income, although that action led to obtaining a loan that was bigger than the one that could have actually been granted if real prices were declared. Same is in decision 39 of 9th of June. The candidate bought an apartment in 2014 for 8,000 euros. The Commission established the actual value was 27,000 euros, but it was sold for 27,000, but the contract set on 8,000 euros. Again, the Commission did not raise or claim to have any doubts. So bottom line is, I don't understand what the algorithm is that the Commission follows. There are doubts about the declaration of the real price. No, there can be none, because in every declaration of assets, there's the real price of the sale, the real price for which the vehicle was sold. In every declaration, that's what there is. And these declarations are submitted and uploaded to the website of the NIA, and that can be looked into. And the most important thing is to analyze the market values. These are realistic, real transactions. This was also done in other situations. So I hope this will be done for me too. To this day, the Commission is not willing to look into the market values for the car Kia Sorento, for Hyundai Tucson, and for that motorcycle. The Commission is not willing to look into the market values of these assets. So I don't understand what doubts can there be, what violations can be raised about me, given that every year, in every declaration, I've been introducing the real prices of the transactions, not a fictional one, but the real one is indicated in the Declaration of Assets and Personal Interests, and these declarations are being checked every year with NIA. So for 2 years in a row, I've been checked. As I said, there is a mechanism, random mechanism, and for verification of the declaration. So that was my case 2 years in a row. And actually, there's like an operative analysis that you have also available to look at. So all of the transactions actually reflect the real market values.
Notice that the Commission obtained sale purchase contracts for cars that were concluded later on. I don't see my connection, but I saw that there were cars worth 20,000 lei. The Commission members have been in Moldova. Did you see cars worth 20,000 lei that are driving through Moldova or in Chișinău? That's absurd. The price mentioned in those contracts is not true, is not real, and I can't know the reasons why those parties concluded such contracts. So in the declaration of assets and personal interests, the actual price is reported, and no doubts can exist about it. I highlight once more, Article 8 states clearly what are the circumstances that are used to apply the financial integrity. Were the assets Well, he's reading out very quickly the provisions of Article 8 about the acquired income. So for which means of transport do I have a non-compliance with this right? Mr. Paniș, it would be good for you to give your explanations, but not ask questions to the Commission. I provided explanations at the initial stage, but I wasn't heard. Okay, with respect to these doubts, I have some questions. First of all, you confirmed to the Commission that you sold the Kia Sorento in March 2017 for 300,000 lei to AM, but less than 9 months later, on 13th of January, the same car is sold again, according to information from public services agencies, for 20,000 lei. Can you provide an explanation for this decrease? Am I mentioned in that transaction? Do you see any suspicions in that transaction? That's a question to you. We need to clarify. Am I a party to the transaction? No, you are not, but I am asking you to express your opinion. Why that happened, do you know? And are there any suspicions in that transaction that we don't blame you for it? I don't know the circumstances of a transaction that I was not party to, that I'm not connected to. But certainly, if that information checked with the public services agency, is that vehicle still on? Because it has to go yearly for a technical inspection, and go to the check with the technical inspection. I think they take pictures of the vehicle, and you could check if that car would be able to drive on the roads of Moldova today, and would that be worth of 20,000 lei? And that confirms that the Commission does not want to check the market prices, but would confirm what is the price of those cars. Why did they sell them for 20,000? Why did they report 20,000? I have no idea. We are asking you. You can't explain. Let's move on. The second question. As it was established during the initial evaluation, in 2012, you purchased a new Kia Sorento for 300,000 lei and sold it 5 years later for exactly the same amount. You explained to the Commission that this had to do with the devaluation of Moldovan lei compared to US dollars. Also, in December 2013, you bought a Hyundai Tucson, manufactured year 2013, for 360,000 lei, which you sold on 24th of June 2020, that's 7 years later, for 256,620 lei. So this time, there was a devaluation of around 30%. Can you explain why, contrary to your explanations related to the Kia Sorento, there was a devaluation in the price of a Hyundai Tucson? That's a false confirmation on your side. First of all, these vehicles were sold in different years. We are talking about 2012 and 2013. Please, we talk about two vehicles. To get to see the real price of the transactions, you just need to check the cost of those vehicles on the market of the Republic of Moldova. The reason why someone prefers a Kia Sorento and someone prefers Hyundai Tucson, I don't know. That is the market price of two totally different cars sold in different years. I am confident that when this question was asked, you did not even look into the inflation rate to see what the prices of cars were in those years. I can't give any other explanations to this. Okay, thank you. In your declaration to NIA, you mentioned the sales price of Hyundai Tucson as 256,620 lei. Nevertheless, according to information from the Public Services Agency, the contractual price for the sale of a car in 2020 was 1,000 lei. Can you explain that price difference.
V-am explicat și la audierea
I
inițială.
explained that during the initial evaluation, these contracts are a formality when the ownership right is registered. There are no such cars at the price of 1,000 lei. The real price of a transaction was reported by me in the declaration of assets and personal interest. This is a price that is aligned to the market price. Why do you have 1,000 in the contract? I explained. And in your declaration, it's 256,000. Why? Will you let me answer? Will you please listen to my answer? I reported the real price in the declaration of assets and personal interest. And exactly as I explained in the initial evaluation hearing, these are standardized contracts. They are just used to transfer the ownership right. Okay, let's move on. During the initial evaluation, the Commission noted that you did not provide any details about expenses worth 2.2 million for the demolition of the old house and construction of a new house during the years 2018 to 2021. During the resumed evaluation, the Commission asked you twice to provide such details, but again, you did not provide any. On 17th January 2019, you obtained a permit to demolish the old house, and on 17th April 2019, you obtained a permit to construct a new house. According to your own information, you spent up to 300,000 lei in the first 3 months of 2019. That is prior to obtaining the construction permit, to pay for the demolition of the old house and for construction materials for the new house. But the costs for demolition were only 60,000 lei. During the initial evaluation, you informed the Commission that the demolition of the old house only began in February 2019 and that prior to that moment, no materials or services were purchased. Can you explain to the Commission how did you incur costs of 231,000 lei for the construction of a new house prior to the submission of the annual declaration in March 2019, although the construction permit was issued only in April 2019? I can, exactly in the way I explained that previously, and I kindly ask for my answers and explanations to be translated and be provided to all Commission members. I explained that before the construction permit, I had a construction for demolition. There were works for demolition of a construction. That real estate was old and it had sewage, gas, water supply connected to it. So all those works required additional money in order to stop the supply of these services to the house, to replace the pipes for everything. And I mentioned that in my answers, there have been land preparation works, demolishing the fence, the gate was taken, a lateral fence was built, which did not exist before. You have all these answers. And for me to understand, the Commission's doubts are about non-declaration of money that I would legally have. Is that the doubt? I should have declared the existence of money that I did not have? The doubts about you are related to inconsistent explanations. Some explanations you provided in writing in one way, initially hearing was in a different way. That's an erroneous interpretation by you. No, you, during the construction, were a judge, and probably you had the task to keep all documents, because it wasn't like 10 or 20 years ago, it was 4, 5, 6 years ago. You are misleading the Commission. There is no separate obligation for judges to have a bookkeeping differently from other citizens of Moldova. Everyone is equal before the law. The same provisions of the tax code are applied. And since we started this topic, you should have let me provide my explanations. In essence, the Commission has doubts about non-declaration of funds that I had in cash. The Commission found that I had legally obtained financial resources and believes that I also had them at the date of declaration. I explained that the declaration was filed on the 29th of March. I was obliged to report in the declaration the funds that I had on the 29th of March, not 28th of March, not 27th of March or 26th of March. And that amount had to be higher than 92 or 100,000 lei. So if on the date of filing the declaration I had not that amount, I did not have obligation to declare it. I could have 90,000 lei in cash and I had no obligation to report that in the declaration. That is what the law provides, if it is applied correctly. So with respect with the obligations that you are invoking, that's an illusion. It is false because judges don't have other laws applicable to them, and there was no reason and no legal provision for me to be required to keep such records. And the Supreme Court stated that in its decision. The Commission just invented this obligation because the tax code does not provide for that. The law on declaration of assets and personal interest did not provide for such things at that time. I would like to draw the attention to the way the Commission treated this case. The Commission found that I would have had financial resources, but I was hiding them, even though I declared them previously. I don't understand what's the logic behind such findings and what would be my interest, because in similar cases, the Commission found, I can give you an example, number 11 of 5 January 2023. Even though this candidate had several omissions in the declarations of assets and personal interest, he did not declare the actual price of the car, the Commission did not find any benefit that the candidate obtained from not declaring. Please speak about yourself. Stop criticizing the Commission. Talk about yourself. The Commission is obliged to ensure equal treatment. And if for other candidates, the Commission saw that white is white, the Commission should do the same for me. I did not have any interest to hide financial resources that I had legally. That's why I require for the Commission to have the same approach to me as it did in other cases. I explained that on the date of filing the declaration, I did not have the amount that would be exceeding 15 average national salaries. That's obvious that the construction works required expenses. I paid for buying materials, and if you make reference to the construction permit, it was issued at our request of me and my wife, based on a technical design filed by us with the local public authority, and we knew based on it exactly what we want to build, how, and we knew what materials needed to be purchased. So there is no logic in that for the previous year for me to declare that I had financial resources legally obtained, and in the next year to hide the existence of such funds. There is just no sense in that. And in other decisions, the Commission found that the candidate did not have any interest or any benefit. So that's very easy. Do you have anything to add to this subject? Yes, I insist for the Commission members to show equal treatment and treat all candidates equally. The cases I made reference to show clearly a difference in approach towards other candidates.
Okay. Nadezhda, you have a question. Please go ahead.
Thank you, Mr. Chairman. Bună ziua,
Mulțumesc, domnule
Paniș.
președinte.
Eu vreau doar să precizez.
Hello, Mr. Paniș. I want to clarify if I understood your answers correctly. In the initial evaluation and today, you confirmed that you had expenses, 2,200,000 lei expenses in the years 2018-2022 for the demolition and construction of your house. Is that right? If that's what I mentioned in the declaration, because I did not analyze all the declaration, that it means when it was like that. And to the Commission's questions during the resumed evaluation, the questions were like, do you have any documents that could show, could explain how much was that cost per year? And you could never show what was the amount of expenses per year. Ms. Skriptievsky, I did not have any interest to keep those documents because I did not know that I would be in the situation to confirm my past expenses. Only after the law on declaration of assets and personal interest was amended, such declaration could be imputed to the declarant. I explained in details how that construction worked, and please pay attention to a similar case. Mr. Paniș, no, just a moment. It's very important. That is involvement of a legal entity. It's about the involvement of a legal entity. And bookkeeping of a legal entity is different from bookkeeping for an individual. In the case number 26 of 13th of March, the Commission accepted that 2017-2018 construction works took place for pleasure. And the Commission accepted the explanations of the candidate who confirmed that by the end of 2020, the property, and that was a second land plot, that was a land plot and a guest house, and then annex, they were put into operation. The candidate provided documentation, Mr. Paniș. Don't mislead, please, don't mislead. Ms. Skriptievsky, that's written in the financial record keeping. Yes, the Commission accepted the detailed cost of expenses, not bookkeeping, but the cost. Yes, but that is financial record keeping. Financial record keeping doesn't include all the documents. Don't interpret it. The decision is very clear. Financial record keeping means all documents. I am asking you, those were not accounting documents, but a detailed cost. Mr. Paniș, you are not part of that evaluation. You please don't interpret. You interpret it erroneously. Make those documents public and we will see. Like, really? Please answer our questions. 2.2 million lei. You paid all that money in cash, and you have no idea how much you spent per year. That's not correct. You mislead people. In the question rounds, in the initial evaluation, I described expenses for every year, and you are insinuating that I have no idea about my expenses? That means that you either did not write. I read them very carefully. I want to understand your today's answer. Read my declaration submitted to the Commission. I read them thoroughly. It shows the expenses for every year. I can find them now and read them once more. I want to clarify if I understood you correctly. You, for 2.2 million, you have no document to show. All expenses were cash, including what you are declaring in your 5-year declaration. All of that is only your declaration. No evidence for anything. Is that right? Evidence for me having had expenses? Any evidence, like you had a contract for service provision, you hired a company to demolish your house. I declare that I did not hire a company. I provided the authorization, the permit for demolition that confirms that demolition works took place, because I showed you a report of final acceptance of a document. To build an object, I need financial resources. This is what I did. I invested in the building of a real estate. All of it in cash. All in cash. There was no reason, no legal obligation to keep those records. Thank you.
Okay. And Mr. Paniș, I have also one more question in relation to this issue, and I'd like to go back with you on the sale in 2020 of the Hyundai Tucson. So as you just explained, there are no cars of just 1,000 lei driving around on the streets in Chișinău, and that the contractual price that you concluded with the seller referred to only 1,000 lei. But as you also explained just a few minutes ago, in your declaration to NIA, you spoke about the value of the car of 256,620 lei. What made you agree with the buyer of that car to include only 1,000 lei in the contract, whereas the actual value, according to your own statement, was 256,000 lei? What made you decide to do that and agree with for such a contract?
Am explicat și la etapa audierii
I explained that during the initial hearing. This is pure formality transaction. Actually, the transaction is concluded between the parties, the price is paid, you go to the Public Services Agency just to transfer the ownership right. That is a procedure where you submit all documentation related to the car. That includes the registration certificate, insurance, technical inspection. You pay the fee for re-registration, and you make a contract. But it's a standardized blank, and most often I think it is filled out by the person on the desk of the Public Services Agency. No one paid attention to those contracts so far. That's why there are such hallucinating and unreal prices, 1,000, 2,000, 3,000, 10,000 lei, because car of 1,000 lei would not even get to be registered with the Public Services Agency, but that's reality. We cannot deny that. Obviously, it cannot be 1,000 lei, obviously, and it wasn't about an intention to avoid tax liability, because I was the seller in that case, not the buyer. So that was pure formality. We probably did not pay attention. I just sold, the buyer bought it. We just went there to re-register the ownership right, and that's all. But I always declared in the declaration of interest and of assets and personal interest the actual price, which is in line with the market price. The Commission would like to check that, as it did in other cases.
Okay, so as a lawyer, as a judge, you find it entirely logical and normal to conclude a contract of which you are fully aware that the price is completely different from the real value. It's not even 1% of the real value. And you think that that is an ethical approach to signing contracts with other people?
Nu, după cum a constatat și Comisia în deciziile la care
the Commission found in the decisions I mentioned, it is an ethical violation. It's not right, but it is not a serious reason to lead to failure. As there were situations until 2021 or 2022, generally in the declarations of assets and personal interest, you were reporting the contract value or the cadastral value of real estate, and we had situations like real estate of 5 or 10,000 lei, but they were actually 100,000 lei. So, but gradually moved to the practice of declaring the actual value. What happened in this case is an old practice. It was happening at that back then, but I did not hide the price. I had no interest to hide the price, no, and I did not get any benefits from that. And because indeed I sold that real estate, and even though it was sold 3 years later. Even the members that are not citizens of Moldova, the value of cars in Moldova cannot be compared with the value of cars in other countries, in the Netherlands or Germany or United States. We import cars, second-hand cars from there, and they cost here much more than in Europe. So it's correct to check the market prices. They reflect the situation. If the price declared in the declaration was correct, then what obligation of mine did not I comply with that would be able to lead to failure? What interest would I have not to mention the actual price in my declarations?
Okay, thank you very much. And this brings us now to the third issue, and I would like to invite Nadezhda Rîcevski to lead the discussions with you on that issue. Nadezhda, you have the floor.
Thank you, Mr. Chairman. Domnule Paniș, cu privire la a treia problemă,
Mr. Paniș, on the third issue, your public statement of 19th January 2022,
cu privire la faptele și dubiile serioase ale Comisiei pe care le-ați primit,
in its statement, the commission that you received, we formulated the following doubts. The Commission has serious doubts about your compliance with the criterion of ethical integrity with respect to your public statement of 19 January 2022, in that the scope and tenor of the remarks may be considered inconsistent with ethical requirements, in that they exceeded the scope of an appropriate response to the accusations against you and also might lack measure and reasonableness. Please express your position first, up to 15 minutes on this issue. First of all, I am going to read a segment from the statement that I received, and I will explain the decision of the decision of a disciplinary board was annulled by the Superior Council of Magistracy. No dissenting opinion existed, so all members of the SCM agreed with the appeal that I filed, and they annulled the decision of a disciplinary board whereby I was sanctioned. And I think it's strange that the Commission has doubts about the competence of members of the SCM, because the statement said that the decision of a plenary SCM wasn't revised by the Supreme Court of Justice. Moreover, the Commission has doubts if the decision of a plenary SCM is in full compliance with the ECHR case. So that's strange when you doubt the qualification of SCM members who passed the evaluation by this specific commission. In my case, as the Supreme Court of Justice found, it's strange that disciplinary deviation was found, that the disciplinary board said that it was not severe and the mildest sanction was applied to me, but the Commission, I don't know for which reasons, believes this is a circumstance that is a severe one. But the chronology of Commission's actions explain in a way why the Commission was so much interested in this issue. My statements about Mr. Urak and Mr. Musteață was addressed in 3 rounds of questions. 3 rounds of questions. Due to the investigation done by TV8, I found who were members of the Secretariat of the Operating Commission and who was the person who accessed my personal data from the Parliament of the Republic of Moldova. And I found that she was the advisor of a former chairperson of the Parliamentary Legal Commission, Mr. Madi, who worked. Mr. Paniș, please relate only to the doubts, and I want to remind you the decision is only the decision of the Commission of the Secretariat. So you are a judge in office. So please obey the rules of ethics without offending other people. If you believe that my actions don't fit judicial ethics, you can file a notification, a report to the SCM to that end. I'd like to remind you that the regulation adopted by the Commission provides for the possibility to declare recusal to members of the Secretariat. And I don't know who those members are. If I knew, I would have accepted that someone from the Secretariat of Parliament would have accessed my personal data. In my specific case, I will make a reference to the equality of treatment, namely, for case 38, in year 23, the Commission found that the candidate had 3 disciplinary proceedings. All those proceedings led to warnings being issued. None of those proceedings were appealed. The candidate did not appeal any of those 3 disciplinary proceedings, and the Commission found that after she got these disciplinary proceedings, she did not have any other disciplinary proceedings afterwards, and the sanctions that were applied did not strengthen the doubts of the Commission. But with respect to me, there is 1 disciplinary sanction that was annulled. So similarly, about me, please remember, please note that after the former member of the SCM left the system, who submitted a secret note with accusations to the Commission about candidate Alexei Paniș, he was not mentioned in disciplinary cases, similarly to the cases after Mr. Urak left the NAC, former presidential advisor, former intelligence service, who also drafted the CIS report on Paniș Alexei about the letter, no disciplinary proceedings started But moreover, after Mr. Urak left NAC, that institution issued a positive operative analysis report about me regarding expenses and income. After Mr. Urak left NAC, the Anti-Corruption Prosecutor's Office started the criminal investigation based on Article 332, Article 2, letter C, that's false in public documents committed by a public servant, that was done in the interest of an organized criminal group. These are two cases that the Commission, in which the Commission shows different treatment. To this end, I explained in the initial evaluation and in the additional questions now that the reasons why I needed to deny the accusations of a criminal nature. I denied allegations of criminal nature, and even if the Commission found that it doesn't comply or found that it was a violation of the Code of Ethics, in no way these deviations that the Commissions found, in no way they can be reason for failing me, exactly how you did in case 38. Is that it? Yes. Thank you. Before moving to the questions, I just want to make one clarification. I am sorry that you continue to use that information. You received an answer from the Commission. The Commission issued a declaration. The data of the candidates that were evaluated by the pre-vetting Commission were accessed by the staff of the Secretariat of the Commission, not of the Secretariat of the Parliament. That was a technical error, the way it was displayed. And for clarity, for the public, that information is completely wrong. I have a report drafted by a bailiff who confirmed, and you have the official answer to that too, that explains that situation. Wasn't accessed by the Secretariat of the Parliament for the pre-vetting Commission. Whether it was accessed in other context, that's a different matter. Now, let's go back to issue number 3. We have only 2 questions. I hope it will not take a long time. Please explain your position on how commenting publicly on the fact that you had no conflict of interest with a party concerned in a presidential decree that you annulled on 31st December 2021. It was party to the case examined by you, and the decision was subject to appeal within 30 days. How is that not public comment on a pending case, while you commented on that on 19th of January 2022? Once more the question, please. I want to understand. In your comments, you said that you were not having a conflict of interest with that person. You made those public comments on 19th of January 2022. So you believe this is not a comment on a pending case that could still be appealed and examined by the Court of Appeal? I reiterate my answer. The comments were an answer to accusations of criminal nature, not to the case that I was examining. Thank you. In your answer to the statement of facts and serious doubts, and actually today also in the 15 minutes, you mentioned that the decision of a disciplinary board finding a disciplinary offense was annulled by the Superior Council of Magistracy, whose decision is final and irrevocable. Please explain this argument. What do you mean, given provisions of Article 8, Paragraph 6 of Law 26 of 2022, according to which, when appreciating criteria of financial and ethical integrity and in making decisions on them, the Commission is not bound by findings of other bodies that have competences in this field. Thank you.
My explanation is specifically an answer to the way in which the Commission produced its doubts or explained it. The Commission stated that that decision was not the object of a review of a final decision by the SCJ. So logically, it had nothing to do with that, but it's still a final one. It is final and enforceable. It is one that is enforced. So it's practically, I worded my answer is that it was not the object of a. What if the Supreme Court of Justice would have looked at it? What if it would have examined it? Would the Commission have taken it into account? You stated the Commission is not supposed, is not expected, doesn't have the obligation to follow other decisions. They're not binding on the Commission. So then what was the purpose? You stated that the decision of the plenary of the Supreme Court of Justice is not enough because it was not supported by the plenary of the SCM, because that was not supported by the Supreme Court of Justice, or that was not examined by the Supreme Court of Justice. But then again, you say that the findings of other authorities are not binding on the Commission. So then what is going on? I understand, Mr. Paniș, there was a misunderstanding. The Commission meant it as a fact, not how you might have interpreted it. Well, is there anything you would like to add regarding this? No. I would only like to ask the Commission to apply equal treatment to all the candidates it is evaluating. Well, stay assured that by law the Commission is required to treat everyone equal and is exercising its duties duly and with diligence. Thank you. But
I have no further questions.
All right. Then I do not see any of the members of the Commission wanting to ask any further questions to the candidate. Since that is not the case, Mr. Paniș, I would like now to give you the opportunity to make a brief closing statement at the end of this hearing. So, Mr. Paniș, please go ahead.
Da, mulțumesc. Deci noi curând sărbătorim 2 ani de privetin.
Thank you. Well, soon we will be celebrating 2 years of priveting. But somehow, if I look at it mathematically speaking or financially speaking, I think that we will have the amount of 1,500,000 as remuneration of the wife of a head of an NGO that is a member, or that is part of the Commission. So we somehow have this tradition of meeting every now and again with the Priveting Commission, and we have the same characters, but we will keep flowing on. Every question that was worded by the Commission, every time there were four rounds, I always try to do my best at providing explanations and details. I wanted to be honest and sincere in all of the answers that I've provided to the questions I was asked, although that certain questions made me feel very suspicious about the good faith and the good intention of the members of the Secretariat. Maybe ask myself questions about their competence, but I've nevertheless answered all of the questions that were raised. I think there were tens of emails, and I was trying to find out who is there on the Secretariat. But certainly one day we will. There's been a TV coverage, though, about the Secretariat. It is only then that I understood who was giving the indications in this whole process, the way in which the Commission acted, the way in which the Commission reacted, rather, to my answers, the way in which the Commission treated me, my situation, tells me that what happens in politics is that's what happens with the Commission. 2 + 2 is not 4. The decision of the Superior Court of Justice on 1st of August, for those who read it, even without having minimal or even advanced legal knowledge, it just shows that the Commission simply did not want to exercise its duties objectively as far as I am concerned. It is clear that failing me was not supported by serious logical reasons, and that's what the Supreme Court of Justice established. And the simple analysis of the decisions that I've already referred to confirms this statement. All of this time I've spent it looking thoroughly into the decisions issued by the Evaluation Commission. And there's more situations, more than the ones that I've referred to today. I just selectively shared a few of them with you. Regardless of the image and ranking of politicians and ambassadors who will be praising the success of this evaluation, this preventing will forever remain characterized by two symbols. The case of Iulian Muntea, that shows a perfect symbiosis between the politics, the NGOs, and the special services, and the hearing of the parents of Ion Chirtoacă. And then on a secondary layer, there will be the civil society, so to speak. And it's very bad, I think, when the constitution is trampled on, as well as logic and common sense, and candidates and their parents are being humiliated and careers are being destroyed. It's worse, though, when we are being told that all of this is a success and that the reform is going well and everybody's diligently doing their work. I am under the impression that these people actually believe what they are saying, and that's bad, because it's like they live in a parallel world. It's like they're torn away from reality. To this moment, I kept believing that this is being done at the whim of some people. But looking at the figures, given the remuneration of people engaged in this process, I understand what the purpose is. The reform is going well and will continue to go well like that for a long time. What the reformers, what the politicians didn't understand is that they created a very dangerous precedent, but nevertheless a good mechanism to get rid of people that are not comfortable to them. And same as the pre-vetting turned into vetting, nobody guarantees that vetting will not turn into a post-vetting. And everything that I count on is the correct application of the law and equal treatment to all candidates. That is everything that I expect of the Commission, for similar cases to be treated in an equal way.
All right. Thank you very much, Mr. Paniș. We have come to the end of the hearing. I thank you for your comments, answers to our questions, and the Commission will now withdraw for our own deliberations, and as much as possible, the Commission will strive of delivering a decision in your case within a month after the date of the hearing. I hereby declare this hearing closed, and thank you again.